So I'm going to be speaking about the question of climate reparations, which I think Sam has captured essentially, which is the question of who pays for climate change. And I'm a lawyer, so we're kind of looking at the question of what that looks like in a legal context. And in particular, we're going to talk about international cases, so not private law cases between private actors. But I'm interested actually in just getting a bit more of a sense of who's in the room from a climate change perspective. I know we've got some physical scientists here, but I was just interested in just kind of a quick show of hands. Who works in climate change or has some kind of connection to it from a professional perspective? Okay, wonderful. So that's great that we have, I think it was only 2 lawyers and the rest of you are doing much more valuable work in this space. Okay, so I'm going to cover 3 points broadly today. The first is the question of what are reparations. I'll go into what that term means at a political and legal level, and discuss some of the historical examples that you might be sort of vaguely familiar with. And then secondly, I'll talk about a really important case from the International Court of Justice, which was decided last year, that focused on the obligations that countries have in relation to climate change, and importantly, this question of who pays. And then thirdly, I'll look at what a climate reparations case between 2 countries could actually look like. And to keep you awake and not thinking about your growling stomachs, we'll have a few kind of pop quizzes throughout the way. So just before I get into that, I was asked to say a little bit about my background and how I came to be working on climate law and litigation. As you can probably hear, I'm an Australian. I'm from Tasmania, which is a little island down the bottom of Australia. It's the smallest and poorest state in the country. And it reminds me quite a lot of Scotland. It's like very rugged, very cold, very dark and gothic. It's quite close to Antarctica. And it's sort of famed for its environmentalism and its environmental movement, which sort of arose in the context of a lot of environmental damage and resource extraction. So the first Green Party in the world was founded in Tasmania in the 1970s, and so I grew up kind of surrounded by a lot of that activism and activity. So I moved to the mainland of Australia, to Sydney, to study. And I studied law, and I worked in a few different areas. Firstly, at the Environmental Defenders Office, so a public interest environmental law organisation. And then later on in the Torres Strait Islands doing Indigenous and native title law. And then finally doing a bit of refugee work. And I found that all those different threads have come together in my legal work on climate change, which affects Indigenous communities, obviously, displaces a lot of people and obviously impacts on the environment. So for the graduate students amongst us, which I think is almost everyone, I was sitting in your shoes or standing in your shoes 10 years ago. I came to Oxford in 2016 and I studied policy and law. And this was a year after the Paris Agreement had been signed. And it was the beginning of the movement of climate litigation, which is essentially using the Paris Agreement and some landmark cases to increase legal accountability around climate change, both to increase ambition and also to focus on adaptation. So I sort of decided to specialise in this new area. There'd only been a handful of cases in that field at that time. There have now been over 3,000 cases in that area. And so I've been specialising in climate law and litigation ever since at the bar as a barrister. So I work mostly in international and transnational cases, so representing communities in the global south who are states that are most affected by climate change, and representing them either in international cases or in domestic proceedings brought by communities in another jurisdiction. And I'm writing a book on climate reparations, which is obviously the focus of tonight. So that's just a little bit about me, but let's jump into the first topic of what are reparations. So they're both, I think, it's a political and a legal term that has both a political and legal history. But essentially, reparations refers to the idea of remedies, a group of different types of remedies, which are provided to address different types of harm. So I'm going to be talking mostly about reparations as a legal concept under international law, but some of the most famous historical examples that I think you might be familiar with include the reparations that Germany paid after World War I, which were implemented or agreed at the Treaty of Versailles. And so Germany there was forced to pay or agreed to pay, I think it was 136 billion gold marks was the initial figure, which is over $600 billion USD in today's money. And they only finished paying off those reparations in 2010. And those of you who have an interest in history will know that reparations were kind of famously weaponized by Hitler as one of the main excesses of the Allies in terms of shaming Germany and imposing war guilt. So I think some of our kind of modern conceptions of reparations have an anchor in this time, and then again the reparations that Germany paid after World War II. And I'm sorry to the Germans in the room. In that case, it was less about a large cash transfer, but it was more a case of the Allies taking a lot of the industrial assets from Germany and basically confiscating them or appropriating them. So it was things like dismantling railways, sending that off to France or Poland, taking ships, imposing forced labour on Germans, and a range of other measures. You might have also kind of heard of the reparations that were paid to the Jewish community and Jews directly. That figure amounted to around $87 billion in today's money, and there were reparations paid to Israel directly as well. Elsewhere in the world, Japan was also paying reparations to the countries and communities that were harmed during their occupation. And just a final example is the US paying reparations to people who were held in Japanese internment camps during World War II, and that was about $20,000 that went to each victim. So these are examples of political agreements to pay reparations for harm in a context that's not environmental, it's not climate change related. But what we're going to talk about today instead is focusing more on the question of reparations as a framework of remedies under international law, under what's known as public international law, which is the law that governs relations between countries. So the main area of law that governs this is the draft articles on the responsibility of states for internationally wrongful acts, which is a big mouthful that basically refers to the law that governs remedies under international law. And those articles create a three-part structure for reparations. And they say that firstly, reparations should take the form of restitution, secondly, compensation, and thirdly, satisfaction. So the idea of restitution is that you need to put the group or the victim that's been harmed back into the position they were in prior to that harm. So to use an environmental example, if you have a factory that's polluting a river on a border, and that river is shared between two countries, a restitutionary measure would be rehabilitating the pollution of that river and restoring the river to the previous condition it was in. But as we all know, that's not always possible in every type of case, and that's where compensation comes in. So, for example, say the river, through the pollution event, resulted in the loss of 5,000 fish, and that impacted fishermen on the side of the state that was harmed. It would be appropriate to pay compensation to that harm, which could not be addressed by restitution. Final category is satisfaction, and these are symbolic acts like apologies, truth and reconciliation commissions, memorials to reflect the moral injury in addition to the legal injury. So in addition to that three-part structure, which I'll come back to a bit later on, those draft articles talk about what countries have to do when they've breached their international obligations. And the first thing is that they need to stop the conduct which is causing harm, and that's called cessation. And secondly, they need to provide a guarantee that they won't restart that conduct. So again, using the pollution example, cessation would be stopping the operations of the factory, which are leading to pollution of the river. And a guarantee of non-repeating behaviour would be to say, we won't turn on the factory again in a way that will pollute the river. So that's just a structure of how reparations works under international law, which we need to understand to make sense of some of the cases in this area, and then therefore what a case could look like in the future. Okay, because I'm getting a lot of blank stares, let's go to our first quiz. And this is a question focusing on trying to think about what do reparations cases actually look like in practice. And so this first question is focusing on compensation that's awarded by the International Court of Justice, the World Court that makes decisions in disputes between countries. And the question is, what do we all think is the highest amount of compensation that the ICJ has awarded in its history? So the way I'm going to do this is just by a show of hands. So just by sticking your hand in the air, put your hand up if you think it is option A. A few takers, a handful. Okay, option B, 375 million. A few more. Option C, 95,000 USD. Okay, and option D, 378,000. Okay, interesting. I'm guessing it's the specificity of the amount which tipped you off, but it's not actually option D. It is option B. And all of these are actually awards that the court has given. So these are all examples of compensation orders that the ICJ has made in previous cases. And this also represents the totality of all compensation orders made by the ICJ in its history. So this is something that doesn't happen very often, and that's one of the challenges, I think, for thinking about this in the climate change context. But very briefly, the 375 million was to do with the case of DRC and Uganda. DRC brought a case against Uganda in 1999, saying that during its war, Uganda had caused harm to them. They claimed tens of billions of dollars in damages, and the ICJ, 20 years later, came to the figure of 375 million. There's other cases as well, which I can go into if people are interested, similarly have very long gaps between when the case is filed and then when the revenues happen. So, for example, the 378 option D took 8 years to get that remedy. So it's not something that moves quickly, which is again another challenge we have to think about in the climate change context. Okay, so let's talk about the ICJ case on climate change, which was decided last year. Has anyone heard of this advisory opinion on climate change? Just hand up if you've heard of it. Okay, 5 of you, great. Let's just talk firstly about what the ICJ is. It's the principal judicial organ of the UN. It's the world court. It's the highest court in the world. It has legal oversight over essentially all areas of international law. The context for this case is that essentially small island nations and other developing countries are understandably quite frustrated with progress under the COP process and have been using the law in different ways to try and get accountability. The strategy was to go to the highest court in the world to try and get a decision from that court on the question of what are the obligations of states under international law to address climate change. What do we have to do when it comes to mitigation, and what do we have to do when it comes to adaptation? And importantly, part of the focus was what happens when you breach those obligations. What are the consequences? And that's a question of reparations. So those proceedings are known as advisory proceedings, which is different to a contentious case where you have two countries coming together over a dispute. Those previous examples were all contentious cases. This is a different type of case which happens in international law where the court just issues an opinion on the law in response to questions that are put to it. So it is formally non-binding, but what it says about all the different obligations carries really significant weight. And because of that structure, it means that any state can participate. So nearly 100 countries participated in this case, which was double the previous record. It was kind of characterized by really unique participation from the Global South in particular. So some people have described it as the biggest and most important case in history, which is potentially a bit grandiose, but I think it gets to the scale of both the question and the level of participation in this case. I'll just mention that there are 3 other advisory opinions from international courts as well, which this one was happening alongside of. Okay, so what did the ICJ actually say about reparations and about climate change? They had 2 questions to answer. The first question was, essentially, as I've mentioned, what are the obligations of states to address climate change? And that posed a question of under which areas of law as well. Is it just the Paris Agreement? Is it human rights law? Is it the law of the sea that governs the oceans? Is it international environmental law? Do we look at all of those different things, or do we just look at the Paris Agreement and the UNFCCC and ignore the rest? And then the second question was, if you breach those obligations, however you define them, what are the consequences? And that's a question about reparations. So the court issued a landmark decision which far exceeded any of our expectations in terms of its ambition, and was kind of viewed as an enormous success, essentially, by the climate justice movement. The first thing they said was that the 1.5 degree target in the Paris Agreement, the 1.5 degrees is the legally binding target under international law, which is a refinement of the position under the Paris Agreement. So as some of you may know, Article 2 of the Paris Agreement says that the global community came together and agreed to try and reduce emissions or global warming in line with a 2 degree world, and make best efforts to hit 1.5. That gap is really important, as the scientists will know, in terms of just the impacts of climate change. Just one fact to kind of draw that out is that 200 million more people will be displaced in a 2 degree world compared to a 1.5 degree world. So it really matters where the court says the actual legal benchmark is. Is it 2 degrees or 1.5? And they said it's 1.5 degrees. They also said that we can look at all those different areas of law that I mentioned before, and not just the Paris Agreement, not just the UNFCCC. And that really matters when you think about states like the US that have withdrawn from the Paris Agreement. And the court has said that even countries that do that continue to be bound under different areas of law to essentially comply with the Paris obligations. So Trump can do whatever he wants, pull out from as many treaties as he wants, he'll still be bound on international law to address climate change. Another really striking decision from the court was that they said that fossil fuel production, consumption, exploration licenses, and subsidies are all potential breaches of international law. And that's essentially every part of the fossil fuel industry. So I think that's arguably the most important part of this decision, because it effectively is the death knell, I think, the legal death knell for the fossil fuel industry. And we're now in a position of trying to integrate and align the rest of international law and international governance with that finding. A few other points, but I'll skip over those. I'm very happy to come back to some of the detail of the decision. On climate reparations, basically the court said that all of the states that have contributed to climate change, which is everyone, are liable to provide climate reparations. And just because one state is liable alongside others, it doesn't mean that they can't be held individually responsible for all of the harm, which basically means that if I'm State A wanting to bring a case against State B, I can bring a case against them for all of the harm that I've suffered in State A. So it creates basically the biggest possible framework for liability and reparations. So that was kind of question A. In terms of question B, they went into the question of reparations and the law of state responsibility, but they were quite sparse about it. They didn't go into in a lot of detail, and the reason for that is because we didn't really have any facts in this case. It wasn't a normal case where you've got a dispute between two parties, a defined set of facts. Their ability to look at the question of remedies was kind of limited to a principled discussion rather than applying it to different cases. So they were quite limited in terms of the types of things they said reparations would be appropriate for. But a really kind of important scientific question was, they said that attribution science can be used to establish liability. And secondly, that the causation question of how one state can be held responsible by another state was not too complex, and that causation was legally possible. Okay, let's do another quiz, just to start thinking about the scope of what all of those decisions actually mean. So this is a really interesting study that was done in 2023 by Fanning and Hickel, where they tried to price, essentially, all of the climate-related harm that comes from the global north exceeding their fair share of the carbon budget, which just means emitting more than they should be emitting. And so they managed to come up with a global figure of all that is owed by the global north to the global south. There's an interesting methodology which I can talk about. But let's see who thinks that they concluded that the kind of total debt essentially is 22 trillion. Hands in the air if you think it's that one. Not a lot of support there. Okay, B, 957 billion. Okay, one over there. One bold soul. Option C, 192 trillion. Okay. And D, 105 trillion. It's C. So a kind of scarily enormous figure. And if you remember back to the last slide, well in excess of the types of damages awards that have been made by the ICJ before, but I think gives you a sense of both the global injustice of climate change and also some of the difficulties around trying to calculate the actual harm. Okay, so I'll just briefly make some comments about how the court addressed reparations in the context of that three-part structure I mentioned before, and then we'll get on to thinking about what does an actual case look like. So on reparations and on that three-part structure, the court said that basically states that are wanting to bring a case have the full panoply of legal consequences available to them, which means that you can essentially do whatever you want under the law of reparations in building an appropriate climate case. On the question of cessation, which is again stopping harm that is harmful, they said this is a forward-looking measure, and it may require the repeal of laws that enable a wrongful act. So, for example, that could look like shutting down state-owned oil and gas companies, or seeking an order that you have no more oil and gas licenses should be granted in a particular jurisdiction. In relation to the guarantees of non-repetition, the state committing to not doing the same thing again, that could look like regulatory reforms, again aimed at preventing fossil fuels or high-emitting industries. And these are things that could be compelled by the court as binding international obligations. On restitution, compensation, and satisfaction, the court said that they didn't provide many examples, but the ones that they did provide in relation to restitution included reconstructing damaged or destroyed infrastructure, or restoring ecosystems and biodiversity. But they said we basically can't go further than this of providing individual examples of what restitution could look like, so we need to wait for a future contentious case and then we can get into it. On the question of compensation, they didn't put a $192 trillion figure on it. So they didn't try and spell out any sort of methodology or identify any particular states that were liable. All they said was compensation is possible in principle, which for someone like me as a climate litigator is all I need in terms of building a future case. And similarly, on satisfaction, the court affirmed the types of things I mentioned before, the appropriateness of apologies, expressions of regret, public acknowledgements, and interestingly, I think mentioned the idea of education of society around climate change and misinformation. So an acknowledgement there of the issues around communicating the climate crisis to people. As some of you know, in judgments you normally have a main judgment and then you have separate or dissenting opinions. And so there are some separate opinions which were provided from some judges who basically wanted to set out some more ambitious ideas about what the court could have said but didn't say. So the Vice President spoke about reparations not being sufficiently addressed in the main judgment and suggested that the court should have gone into identifying what the methodology should be around monetary compensation and talking about remedies being appropriate or reparations being appropriate to provide reforestation, to focus on biodiversity recovery, coastal erosion, technology transfer, infrastructure building, and I think this is particularly interesting, he spoke about disaster and debt relief as one of the reparations, which is, I think, a particularly big problem in the climate space where you have debt-burdened countries in the global south dealing with extreme weather events, going into further debt to try and deal with those costs, and they're trapped essentially in a vicious cycle that's made worse by climate change. And so a separate judge, Judge Bandari, he is known as a bit of a rogue and put in some really wonderful and helpful things from the perspective of lawyers like me. He said quite explicitly that cessation, so that ceasing the wrongful act, means cessation of fossil fuel extraction, consumption, and subsidies. He kind of said the quiet bit out loud. And in terms of restitution, he listed a big long list of things that are appropriate. Things like protecting greenhouse gas emission, GHG sinks, rebuilding destroyed infrastructure, restoring territorial and marine habitats, rehabilitating ecosystems, returning lost territorial property, which I think is a really interesting question if you're thinking about sea level rise, and restoration of land rights to displaced Indigenous people, which I think is also a pretty fascinating question. And interestingly, Judge Bandari recommended that the UN General Assembly create a reparations commission to deal with the claims of the vast number of victims all over the world. And that is something that now Vanuatu is pushing for through the UN General Assembly. So you can see a kind of a lawmaking function from this aspect of the judgment. Okay, so slightly mindful of time, let's go on to the final topic, which is thinking about what a contentious case should actually look like or could actually look like. And one of the kind of threshold questions here is, who can you sue and where? I think the most obvious one, and the one I'll talk about today, is the ICJ. It's the World Court. Everyone's essentially a member of it. It has the most authority, but there are other courts and tribunals that you can focus on. There's a specialist tribunal, the International Tribunal for the Law of the Sea, which governs the oceans. That could be an alternative forum, but I'll just focus on the ICJ. And I have another quiz for you connected to this. So the ICJ, as I said, is the principal judicial organ of the UN. It's kind of like the UN's Supreme Court, the Constitutional Court. But not every state can automatically be taken to the ICJ. A country needs to make a declaration accepting the court's jurisdiction in cases that are brought by other countries that are contentious with them, which narrows down the group of states that you can actually sue using this case law. So the question is, how many states have made that declaration accepting the compulsory jurisdiction of the ICJ? Do we think it's all member states, 193? Anyone in favour of that? Nope. Option B, 101. Quite a lot of support there. Option C, 38. Okay, not too many pessimists about the international rules-based order, which is nice to see. Option D, 74. Great, yeah, it's option D. So most of those states are in the Global South, but importantly, not all of them are in the Global South. You see basically no countries from the Middle East, no oil-producing states from the Gulf region. But importantly, you do have on that list the UK, Australia, Germany, Italy, Spain, and Japan. And so I think it's slightly ironic that because those countries are essentially being good global citizens by saying, you know, you can sue us if we've done something wrong, they've now put themselves in the crosshairs for a contentious case. So let's think about what that case actually looks like. And there are kind of a few different options for a case like this. The first question is it an individual country or a collection of countries that bring the case? And both are possible. So you'd probably think that it makes sense to have a coalition of states that are harmed bringing a case against maybe a collection of the states that are responsible. But the main difficulty with that is just the factual complexity of then substantiating all of the different climate-related damage in all of those different countries and arguing all of that at the ICJ. So if you've got 10 countries, for example, where you need to assess the damage, financialize it, put it into a quantitative figure, that's an enormous amount of work, and we just don't really have that data and that information. And also the types of states that are bringing these claims don't have a lot of money. Most of the legal work that was done for this case was done for free. All the work that I did on it representing the Solomon Islands was pro bono. That was true for pretty much all of the council working for smaller states. So there's a big resourcing issue around whether or not you can actually build the evidence base to bring a big joint claim. Another structure that could work is one case that everyone kind of supports, brings the first claim, and then other countries file to intervene in support of that country. And so those of you who followed the South Africa and Israel genocide proceedings before the ICJ might have seen there are a bunch of other countries joining that case in support of South Africa. It will be a similar structure in these proceedings. So just in terms of those evidentiary issues, you also need to think about the climate science and the attribution. So showing from a scientific perspective that you can attribute the harms in a particular place in terms of a particular community to climate change. That's pretty expensive. It takes expert scientists to do. And it's possible, but it's not that straightforward. And then I think kind of I was going to say $1 million question, but $192 trillion question is what remedies are being sought. And this is where there's a choice between those three categories. Do you go for restitutionary measures, rebuilding schools, rebuilding infrastructure, restoring ecosystems, or do you go for the big compensation claim, or a combination of the two? And I think that can then also affect this question of what type of case you run, because it's possible to do something called bifurcation, where you run the proceedings in two stages. You could have an initial stage, which is focused on those restitutionary measures, or maybe just trying to shift the policy of the state that you're suing, so that's cessation focused remedies, trying to kill off the oil and gas industry, for example, trying to stop them subsidizing the fossil fuel industry, and not seek compensation or remedies for the harm that your country is suffered. So kind of like a good neighbor approach. And you could do that, win on that basis, hopefully, and then have a second stage of the proceedings where you claim all of the harm. So that might make it easier to have a joint claim. And so aside from all of these legal technicalities, there's also the political question of who gets to decide which state brings the case, right? Every state that has been harmed can bring a case against any state that is responsible. So essentially everyone can bring a case. Who gets to decide who brings that case if it's going to only be one or a small coalition of states? And that's fundamentally a kind of a diplomatic and political question. But there's a risk inherent in that, which is that a poorly funded or poorly prepared state with a poorly developed case that doesn't have the evidence that it needs might just be in a rush to file a bad case, which everyone else then feels the need to support, and we're in a pretty tricky situation there about whether or not we can actually use this amazing precedent in the best way possible. So these are some of the questions that I'm thinking about as someone who works in this area, and the rest of us who are thinking about this topic are sort of grappling with. Something I didn't get into is the relationship between these proceedings and the COP process, which maybe we can pick up in the Q&A, Sam, but I was a COP last year, and my job was to advise small island states on how to use the ICJ decision in the negotiation process. And this kind of spoiler alert is that it wasn't used very well. And I think there's a lot that we can kind of learn from each other in the diplomatic and in the legal space. So just to wrap up, I think this is a really exciting and interesting phase in legal accountability when it comes to climate change. But I also think there's not much understanding about these really seismic developments in international law. And I think that's kind of a communication problem and ultimately a political legitimacy issue. In the scenario in which, for example, a case is filed this year against the UK, what is the popular response going to be in the UK to that case? I imagine it'll be quite negative at the moment. So I think there's kind of a awareness raising and communications issue for the climate movement and lawyers working on this. One final thing is I haven't spoken about domestic cases, so domestic climate reparations. I'd call them kind of compensation cases, but I'll just briefly say that they are basically exploding cases against fossil fuel companies brought by communities in the global south that are harmed by climate change. There was a really key development in a case last year which basically made it possible to bring those types of claims. So I think that we're kind of tipping into an era of accountability where the fossil fuel companies will be starting to be held liable for big damages claims as well. Okay, so I'll leave it there, and I'll just quickly run through my questions for you all. So I'm mindful that some of that might have gone over your heads. So the first question is, and feel free to answer whichever one you want, are international courts an appropriate vehicle for determining who should pay for climate change related harm, so climate reparations? And secondly, are there any moral or philosophical issues with developed states, i.e. the states most responsible, and their citizens and companies being held liable for emissions from the 19th century onward? And if they're not liable, then who is? So yeah, I'll leave it there. Thank you so much.